It is 9 a.m. The office is loud. Someone drops a stack of folders, and the sound makes your whole body flinch. You spend the next 20 minutes trying to calm down enough to focus again. If you live with PTSD, this might sound familiar, and here's something a lot of people don't know. PTSD can be a legally recognized disability, which means in many cases, you have the right to ask your employer for support. Today, we're breaking down what that actually looks like, what the law says, what accommodations really are, and why requests sometimes get denied anyway. Post-traumatic stress disorder, or PTSD, is a condition that can develop after someone experiences or witnesses a traumatic event. That could be combat, an assault, a serious accident, a medical trauma, or childhood abuse. The cause can vary widely from person to person, and symptoms that often show up at work include hypervigilance, so feeling constantly on alert, trouble concentrating, flashbacks or intrusive memories, sleep disruption, avoidance of certain people, places, or tasks, difficulty regulating emotions under stress, and lots more. So none of this means that someone is broken. It just means their nervous system is responding to something real. And for many people, it's serious enough to affect daily functioning, which is where the law comes in. Here is the key idea. A condition counts as a disability when it substantially limits one or more major life activities, so things like concentrating, sleeping, communicating, or working. Not everyone with PTSD experiences it in the same way. For some, it's manageable day to day. For others, it significantly disrupts their ability to function at work or home, or maybe even go to work at all. Severity is personal, and the law is built to account for that range. Important takeaway: if PTSD substantially limits your daily functioning, you may legally qualify as having a disability, even if you don't think of yourself that way. In the United States, the main law here is the Americans with Disabilities Act, or ADA. It applies to employers with 15 or more employees. Under ADA, PTSD can qualify as a disability if it substantially limits a major life activity. When it does, employers are generally required to provide reasonable accommodations unless doing so would cause what's called undue hardship, meaning significant difficulty or expense for the business. This usually works through something called the interactive process. So the employee requests an accommodation, the employer engages in a dialogue about the need, and together they try to land on a workable solution. And a quick note for viewers outside the US, many countries have similar protections. The UK has the Equity Act. Canada has various human rights codes at the provincial and federal level, and other countries have their own frameworks. So if you're not in the US, it's worth looking up your local employment and disability laws. So how do you actually do this? So disclose to HR or your manager. So you don't have to share the full diagnosis or trauma history. You just need enough to explain what you're asking for to justify the request. And then get documentation if requested. So a note from your healthcare provider describing functional limitations. And again, it's not necessary to document every detail of your history because you do have HIPAA. And 3 is to put it in writing. Even if you just have a conversation first, follow it up with an email, something in writing. This creates a paper trail in case there's ever a dispute later. You don't also have to say the words PTSD if you're not comfortable. You can frame the conversation around what you're experiencing functionally. For example, I have a medical condition that affects my concentration in loud environments. So a documented diagnosis often strengthens the process, but you're in control of how much you share. Let's get concrete. So reasonable accommodations can look like a lot of different things depending on the person and the job. So here are 5 categories. So the first one's environmental. So things like noise canceling headphones or a quieter workspace, totally reasonable. A private or low traffic desk location, again, reasonable in many cases. Adjusted lighting is another one. Lots of people have sensitivity to light. Schedule related is another area, so flexible start and end times, ability to take breaks as needed, remote or hybrid work options, advance notice of schedule changes. Those are reasonable too. The third category is communication and process, so written instructions instead of only verbal ones. Advance notice before meetings, especially large and high-pressure ones. A single point of contact for feedback rather than juggling multiple supervisors can also help. Fourth category is leave-related, so intermittent leave for therapy appointments. Lots of people ask for that. Extended leave during acute episodes where laws like FMLA apply. Also reasonable. And the fifth category is support-based, so permission to step away during a flashback or panic episode, a discrete code word or signal system with a trusted manager, and temporary modifications to your duties to avoid specific triggers. All of that's reasonable. None of these require an employer to lower performance standards. They're about adjusting how the work gets done, not whether it gets done or the quality of work. So I want to be clear about that. Now, let's look at why accommodations might be denied, because the harder truth is that accommodations aren't always approved. And here's why that happens. So undue hardship. The employer argues that the cost or disruption is too significant. This has to be a genuinely substantial burden, not a mild inconvenience. Direct threat. Rarely applicable, but sometimes employers claim the accommodation creates a safety risk. Insufficient documentation is another one. The employee didn't provide enough medical evidence linking the limitation to the specific accommodation requested, which also leads to vague requests. So asking for something really broad, like more flexibility, is harder to act on than a specific actionable request, like a 30-minute shift in my start time. The employer bias or misunderstanding is another reason. So sometimes denials happen because of stigma or ignorance about mental health conditions. That's illegal, but it still happens in practice. The other one is company size. Under the ADA, businesses with fewer than 15 employees may not be legally required to comply, though some state laws set a lower threshold. So if a request is denied for a legitimate reason, there's often room to propose an alternative accommodation. If it's denied unfairly, you do have options. So if your request is denied and you believe it's unjustified, ask for the denial in writing along with the reasoning behind it. You can consult an employment attorney or a disability rights organization. Many offer free initial consultations. You can file a charge with the EEOC in the United States, but move quickly since there are strict filing deadlines, typically 180 to 300 days, depending on your state. You could also consider mediation before jumping straight to litigation. It's often faster and less adversarial. Needing support at work isn't a weakness. It's a protected right. Knowing your options, documenting your requests, and understanding the process can make all the difference. So if this was helpful, check the links below for EEOC resources and PTSD support organizations, and let me know in the comments. Thanks for watching. See you next time.